Hi guys, this is going to be the first content lecture that we're going to have this semester. We're going to be talking about ethics this week. We're going to be spending some time talking about business ethics, but before I get there, what I want to do is talk a little bit about paralegal ethics. Now, this is one of those areas that is not covered in the textbook, in the business law textbook, but I want to spend a little bit of time talking about it because it's kind of an important thing to understand. First off, you may have been exposed already to some lectures on ethics, some lessons on ethics. Those are very important, but I want to kind of reinforce those themes. And frankly, if you haven't been exposed to it, it's something that is really important. In my experience, one of the areas that I see people get into trouble with are ethical issues, including paralegals. There are some different kind of pitfalls, to put it bluntly, that people can fall into. And this is really one of the areas where you really can get into quite a bit of trouble if you don't watch yourself. And so that's why I think it's important to cover it here at the beginning of the semester and just reinforce some concepts. I'm not going to spend too much time talking about it. I'm not trying to beat anyone over the head with it, but I am hoping to be able to kind of go through some of the different material and some of the different things that we're going to be talking about just to help you understand. One of the things that happens is if the attorney gets into trouble, the attorney can potentially have issues with regarding their law license with the state bar. And one of the places where they can get in trouble with is if the paralegal or the investigator or a legal secretary or whomever in their office are doing things that they're not supposed to be doing. The attorney themselves can wind up getting into trouble for the actions of employees, because one of the ethical duties of an attorney is not only to behave in an ethical manner, but also to supervise those other people around them to make sure they're doing the same. Now, what I'm going to talk to you about in this video is going to be basically 10 rules, 10 different rules that we should be considering as far as going forward. These are things that I made up myself in regards to the ethical rules that I think are important. It's not about morality. I'll talk about a little bit about morality later when we talk about business ethics. This is more these rules that hopefully you'll be able to understand and follow, and they're very important. I put these 10 together because they're the ones that I've seen people get into trouble with most frequently. And so that's kind of what I'm hoping to be able to share with you. So let's start out. This video is going to cover the first 5, and then the next video will cover the last 5. Okay, so the first thing that we're going to be looking at in regards to our consideration for paralegals are my 10 basic rules. First is CYA, protect yourself. Okay, now you may think, well, that doesn't sound like a very ethical rule to me, but here's the deal. Everything that we're going to be building on is going to be about protecting yourself from issues that may come up, protecting yourself and the law firm from different things that may arise. Okay, that's why it's CYA. So let me give you a scenario, and I love doing examples, so I'm going to do tons of them as the semester goes on. It's a Friday afternoon. You're at the law firm, you're by yourself. No one else is there. The attorney is out, doing whatever the attorney does on Friday afternoons. You get a phone call, and it's the deputy of one of the courts, and they're calling you about a case. Let's say it's the Guerrero case, okay? And they're saying that the judge wants to set up a hearing 8 o'clock Monday morning. Okay, now, it's Friday afternoon, close to 5. Normally, when you have a hearing set up for someone and for a client, you might send a letter, maybe even a certified letter, to let the client know, hey, this hearing is coming up. It's an important hearing. Let's assume that this is a criminal case. So basically, if someone doesn't show up, there can be a warrant issued for their arrest. It's pretty important stuff. However, because it's Friday afternoon, you don't have the time to send a certified letter and hope that the client gets it the next day or on Saturday or by Monday, before 8 o'clock in the morning. What realistically you're going to be left to do is make a phone call. So you call the attorney says, okay, fine, I get it. Make sure you call a client, and that's what you do. You call the client. The client answers. You tell them, hey, you have a hearing Monday morning. You need to be there. The client says, I understand. Hang up. Boom. Monday morning rolls around. It's about 11 o'clock. The attorney comes in, and they tell you that they had hearings all morning long, so this was one of several hearings. but they tell you that the client missed the hearing. Basically didn't show up. But oh well, that's what happened. The attorney called the client never answered the phone. So what happens? A warrant issues for their arrest. And, this isn't the biggest deal in the world, so they're not exactly breaking down doors trying to find him, but the warrant is out there. A year and a half passes. The client is driving along when he's pulled over by a police officer, and the police officer does a warrant check during the course of doing the traffic stop, finds the warrant, arrests the guy for failure to appear in court. Happens all the time. The client says, I never knew about the hearing. No one ever told me. What was I supposed to do? That happens all the time too. It brings me to one of my corollaries having to do with CYA, which is this. People lie. Clients lie sometimes. You may have witnesses lie. You may have family members who lie. You may have other paralegals, attorneys, courtroom staff, police officers. People lie. We lie a lot of times because we're in trouble. We panic. And that's what that client is doing. That client knows they're in trouble. So one of the first things they'll say is, I didn't know. Now, a lot of times, it dies down. That's all that happens. The client says, I had no idea, and then it goes on. But sometimes clients can be very persistent. And they say, no, you know what? I had no idea. I didn't know. When they go in front of the judge, they tell the judge, the reason I didn't show up for your hearing was because I didn't even know I had it. Now, if they're telling the truth, they're right. They're being wrong. If they had no idea about the hearing, they shouldn't be in jail. But if that happened, a mistake was made along the process. And they're going to go back and try to figure out where that mistake happened. Now, here's where it comes back to you, to us. If you made a mistake, you made a mistake. Deal with it, go forward. However, if you didn't make a mistake, you should be protecting yourself. So, in the example that I gave you, where you notified the client, you know full well, you told him. You had a conversation with him. He said he was going to be there. Yet he didn't show up. And now he's putting the blame squarely on you. So how do you protect yourself in this scenario? CYA, you document. Document. The first rule of ethics is really document what's going on in your case. You will find that if you keep a record of everything that's going on in the case, the major things, okay? You don't have to keep every small little thing, but the major things, conversations, calls, talking to witnesses, this is going to serve you immensely when there are accusations made that you either did a bad job or you were unethical. Because now you can point to the documentation to say, look, I did call him. Now, for example, how do you document? Well, one way is the log that I have up here. And this is just an example, but basically it has name, phone number at the top. You'll notice there's a date, a time, and then a communication summary. Here you can put your initials. So as an example, you talk to the client Guerrero, you fill out your initials, the date, the time you called them, and then you write, informed client of hearing. Client understood would be there. Boom. Because a year and a half, 2 years, 5 years, whatever, when they come back and accuse you of having not called them, you can point to this and say, no. I called you. It's documented. It's noted. You're also not having to rely on your memory. You may have a photographic memory. If you're one of those rare people, great. But most of us don't. I don't. Okay, I forget stuff. I may not remember who I talked to last month, but I can always go back to my file. I love it when a client says to the judge, and it happens. Clients get upset with you and they tell you, my lawyer's never talked to me. He's never visited me in jail. And what can I do? I pull out my file and I have by dates. Oh yeah, I visited you on this date, August 25th, September the 4th, October the 10th, October the 28th. I can actually cite to dates. That's very powerful evidence that I visited the person. And all of a sudden they back off. Oh yeah, well, it's true. Because as opposed to me saying, well, Judge, I visited him. Well, how many times? I don't know, 5, maybe 10, I'm not sure. No, I can now count down the exact number and even give you the day I went there. Now, you don't have to use this tenant communication log. You can use some other types of systems. Email, if you write emails and you tell the boss, hey boss, I talked to this client, he knows about the hearing, boom, that's a way to document. That's acceptable. You can use electronic means to document. You can have an electronic log system. Whatever system you use, make sure that one, it's reliable. In other words, that it's something that you can rely on in the future. If you're using email, don't purge all your email every year to save server space, because that basically destroys your documentation. Same thing, you may like to do Post-it notes and put them all over your computer screen, okay, like an ad hoc frame around your computer screen. That's not a good documentation system. It's going to be very difficult to find what you need. The second thing, though, is it should be a system that you're comfortable using, because it can be a pain. It can be a little bit getting used to writing out, or typing up every time. Use a system that is easy for you to use and is very intuitive for you. If you love to write write email. I like these logs. I like to put them in the front of the file and just write down on the log, and it's a very helpful type system. So remember, document. And I'm going to even touch back on this as we kind of go forward. Now, communication, rule number 2. Number 1 complaint of lawyers: they do not return phone calls. We have an ethical obligation to keep the client informed of everything that happens in their case. That means communication. Many attorneys use their paralegals as go-betweens in communication. So you have to communicate regularly with the client. This is an important thing. Many attorneys, when they get into trouble, it's because they don't communicate with the client. Example, you represent someone in a car accident, and the other party offers money as part of a settlement, and the lawyer never, or the law firm never lets the client know about the offer. Bad, 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 okay? That's lack of communication. It's an ethical violation. We have to keep in touch with our clients. However, how do you deal with abusive clients? Sometimes clients will call and be abusive towards you, towards the staff, towards the firm. This can take all sorts of different shapes and sizes. It can be clients who scream and yell and argue. It can be clients who are profane, they use profanity. It can be clients that basically creep you out, okay? Any of those things, you do not have to take it, okay? By saying that you have to maintain good client communication, that does not mean you have to take abusive behavior, okay? The thing that you have to do is basically report it first off to, your boss, the attorney, whomever is higher up, and say, look, this person is behaving inappropriately towards me, or this person's just giving me the creeps, or they're screaming and yelling every time they call. I don't want to have to deal with them anymore, and you don't have to. Now, how do you protect yourself, though, from a client who will claim later on, hey, I used to call my lawyer's office and they stopped taking my calls, I could never communicate? Again, document. Rule number 1, right, comes into rule number 2. What you're going to want to do is you're going to write down every single time client called up and was cussing at me. And you're going to document the time when you told the client, sir, if you keep, calling us and just going off on us and swearing up a storm or screaming and yelling, we're not going to take your phone calls anymore. You're going to be able to create that record for purposes of making sure that if they come back and complain, you know why you stopped taking their calls. Rule number 3, confidentiality. Okay, so this is a big one. There are a lot of issues that arise in regards to making sure that we keep our clients' confidences. Okay, first and foremost, clients' secrets must be kept. We represent the client. This is one of the most important fundamental things you always do for a client. You want to keep their confidences, basically keep quiet regarding things that are going on with their case. Now, does that mean you can never talk about your cases that you're working on with, say, your family and your friends? No, it doesn't mean that. You're not in the CIA, okay? You can talk about interesting cases, oh, we represent this guy and he was so drunk he peed himself, that kind of weird stuff. That happens. People behave real crazy. Now, here's the deal, and you're going to notice this in the way that I teach the class. I never use clients' names. I use a lot of examples. I use a lot of analogies. You will never once hear me give a name. You will never once hear me give a description, okay? Teach yourself to do the same. Don't ever, ever, ever repeat a client's name to anyone else. El Paso, for being a big city, is a small town. And it's shocking to me how often people know each other. Okay. If you start giving names, even first names, people can figure out who you're talking about, and you have violated client confidentiality. Even for seemingly mundane matters, people can get offended if other people know their business. Okay. So if, for example, you represent someone on a DUI and you're like, man, they were so drunk, they were falling all over the car. And oh my God, I saw the video and they look horrible. Never, ever, ever share a name. Don't use any identifying information. Don't say, oh yeah, they drove a car with, this bumper sticker on it. Or, oh, they got arrested on this date at this intersection. Because people can start putting things together. Okay. Very, very important. Also, I warn you, don't ever give information out over the phone. You'd be shocked. There are some attorneys and some paralegals who are very, very good at this. They will call up your law firm, looking for information. And when they call, they're very friendly. They seem very natural to talk to them. Okay. So for example, let's say you're representing someone in a personal injury and you guys have been going back and forth about how much the client is willing to accept as a settlement. Opposing counsel, and I've seen this, can call and say, oh, hey, how you doing? I'm Larry. Hey, so you're representing so-and-so, right? So, yeah, so, how much would he be willing to take? And all they're doing is they're fishing for information. Now, what they're doing is they're just asking a question. There's nothing wrong with it. What's wrong with it is if you start to talk about the client's case over the phone with somebody, okay? And this happens to me even now. People will call me up just randomly looking for information on cases, looking to see what I am willing to tell them, and you want to be friendly. That's the thing. This is very disarming. It's not like they're calling you and demanding information. They're being so nice that you almost feel like you want to be nice to them. Don't. Remember, do not give information out over the phone. Do not give information out to other people. Keep the information in-house. Okay. Now, how do you deal with family? This is also a tricky issue. Some clients are comfortable with you talking to family. Other clients are not. They don't want their family to know. Okay. Some clients, in fact, don't even want any kind of information coming out at all to them. Always find out what your client's wishes are before you talk to the family. Whenever I take on a new client, if the family shows up, I always meet with the client first by themselves. Now, if it's a minor, that's something different. We're not going to go into that. But I'm talking about an adult, okay? They show up, always take them aside, privately meet with them. Don't ever sit down and assume that they want the family to know what it is that's going on in their life. Take them aside. Now, a lot of clients are like, hey, it's cool, my wife, my mom, whomever, she can know everything about me. Awesome. Then you can involve them in the discussions. But always make sure that that's in fact what they want. Divorce cases, I list these here separately because they're very sensitive matters. Some people, and this is not a cool move, but some people will come in and ask for divorce papers to be prepared without the spouse knowing that they're going to get divorced. I've seen it happen, guys, where guy comes in, says, I want to divorce my wife. She has no idea it's happening. He tells the lawyer, look, serve my wife with the papers, with the divorce papers this weekend. I'm going to be out of town, or I'm going to move my stuff out. And that's going to be that. They don't want the confrontation for whatever reason. Not a cool move, but you got to keep the confidences. Do not go out and call the family and tell them what's going on, the wife or the husband. It's not your job. It's not your position to try to, kind of circumvent that. Basically, you got to keep your confidence in divorces. Things are going on. People are just making decisions. You got to make sure that you understand you cannot go around behind a client's back and let people know. Also, you might get phone calls. It happens where you may get a husband or a wife, say, who go home and they leave the business card of the attorney laying around, or they leave it in in their pants, and it's during the laundry, the spouse pulls it out and says, what's this business card doing here? Why are they calling? Why are they going to visit a lawyer? They may call your office and say, hi, what are you doing? What's your business with my husband? Or what's my business with my wife? Why is she going to talk to you? You cannot give that information out. In fact, it would hurt just for them to know that they're seeing the attorney. So here I would counsel you to take my first corollary and lie. You may have to lie to protect client confidentiality. You might have to say, well, sir, ma'am, I don't, because the minute you say, if the wife calls you angry and says, why is my spouse, Johnny, going to go, why is he seeing you? And you say, well, ma'am, Johnny's our client. We can't divulge any confidences. You've kind of already let the cat out of the bag. She's already going to be able to figure out what's going on. So you may have to lie and just say, ma'am, I don't know what you're talking about. We don't have Johnny as a client, that kind of thing. And again, it's all because you're going to try to protect your client's confidentiality. Remember, if you blurt it out, if you tell you're going to be hurting their ability to keep things secret that they want to keep secret. The last thing I mentioned here is cyberspace. Be very, very careful in cyberspace. I'm talking here about social media, Twitter, Facebook. I see young attorneys get into trouble with this. They come out of law school. They've been working for a little bit. They get their first big win. They want to share it. That's great. That's wonderful. The problem is, do not put up the clients' names. Do not put up their pictures. I've seen lawyers do that. Hey, we want our first case. Can you do that with the client's permission? Sure, but you should get the permission in writing. Be aware the client may change their mind eventually. They may not want it to be known that, hey, I was accused of committing a robbery, but I was found not guilty. Great. That may not be the type of thing they want to make public. So it's better not even to delve into that. Also, the other big issue with social media, cyberspace, the internet. Remember, not only are you violating client confidentiality, you're creating evidence of it. Okay, it's one thing to say, oh, I was at a party and I blurted out someone's name, and then it becomes a he said, she said. It's a completely different thing to put the client's name online. You're basically sealing your fate. It's right there for everybody to see. So always keep your client's confidences in public. Now, conflicts of interest. This is rule number 4. Okay, it's very important to understand that loyalty is owed to only your one client. Okay, and I've already kind of referred to this a little bit before. Basically, you have one client. It's that person who's come in and hired you, or you've been appointed to represent. You don't represent their family. You don't represent their spouse. You're not going to be trying to do those kinds of things. If you think that your client is in the wrong, it's not your position. There'll be other people that will be judging your client. There'll be other people who are trying to figure out what's the right thing to do in this case. That's not your place. Now, one of the other issues that I always bring up with conflicts of interest is dating. Okay, and this is not a classic conflict of interest issue, but it's the place that I feel the best to talk about it. Here's the deal. If you, ethically speaking, it is not unethical to date a client or to date a witness. That doesn't mean it's a good idea. Okay, one of the places where I see people, including paralegals, get into trouble is when they get romantically involved with clients or witnesses. The reason they get into trouble is because it begins to create other ethical issues. For example, I've seen where paralegals get romantically involved with someone, and then there are claims, that's a client, and then things go bad. The client turns around and makes an accusation that the paralegal violated confidentiality, that she was running around telling everybody about his case. Okay. Also, I've seen instances that are more serious. I've seen instances of paralegals going to prison because they started to date people in gangs, and the people in gangs started to ask them to do illegal activity, like getting confidential documents, like passing along files, again, of other clients. So in other words, this person says, hey, go and get me information on these other clients that you have, and they wind up passing this information. Very, very bad things. So I would stay away from it. Now, your firm may have a policy. We have a policy. At my office, you cannot date clients' family members, witnesses, or witnesses' families. That's an important rule because it helps to prevent issues that come up because of this. If you start dating someone, be aware. I would tell the attorney that that's what's going on. So let me give you an example. Let's say that you're dating somebody, and then one day you discover that a client of the office is the cousin of this person. Okay, I think one of the worst things you can do is not say anything. Now I get it; it's your personal life, and some people are very private. And they say, "Hey, it's not anyone's business." The problem is now your personal life is intersected with your professional life. If you don't say anything at all, you run the risk of something happening in the future, and then the fact that you didn't say anything winds up becoming a suspicious thing. Like, wait a minute, why didn't he say anything about the fact that he was dating this person's relative? Like, that's very suspicious. And now people are making accusations. Again, these types of things happen. There's these types of breakdowns that happen. People lie. My first corollary, right? So the client's case goes down, and they're going down in flames. They get desperate. They start to make up stuff, lies about you and about the situation. And then, oh, it's because they told the whole family about my case, but it's because they were dating the boyfriend. That kind of a thing. What you should do is if you do find out a relationship like this, or maybe not even a dating one, but just a family relationship, tell the attorney. The attorney can take steps, okay? Such as creating what's called a China wall. A Chinese wall is basically segmenting off the information so that way nobody can see it, okay? The other conflict of interest thing that I want to talk about, it has to do with divorces, okay? Be aware that if, and where I see it is where students will come to me and say, hey, me and my spouse are getting a divorce. We decided to divorce, but attorneys are expensive. He said he's going to go hire a lawyer and that he will go ahead and pay for the lawyer, but he told the lawyer to be fair and split everything 50-50. Understand, the lawyer does not represent both of you. The lawyer is not a judge. The lawyer is not a mediator. The lawyer is not going to try to do a 50-50 split. Quite on the contrary, because they represent one party, they have to put the divorce agreement slanted to that one party's side. I've had students who have brought me divorce agreements and said, should I sign this? And it was prepared by my spouse's lawyer. Should I sign it? I never, ever have told a student to sign it. The simple reason why is because it's always slanted against them. There's always things there. And it's not so much that the spouse is being dishonest, it's that the lawyer is doing their job and preparing that document in a way that helps their client, which is what they're supposed to be doing. I always tell students, if you're in this conversation and your spouse is saying, hey, I'll go hire a lawyer, say, no, don't worry about it. I'll go hire the lawyer, okay? Because that way, when that document comes on and it's slanted, it's in your favor. The last thing I want to mention in terms of this video, and I'll pick up again on the next video, is the issue of fees, okay? Very important to know how to handle fees, okay? So the first thing that you see there is called an IOLTA account. Basically, it's a interest on lawyers trust account. Basically, what happens is this is a separate account that is maintained by the law office, okay? So basically, law offices, the way they're going to operate is they're going to have an account that pays for their expenses, and then they're going to have a separate account, which is called the IOLTA account. It's a trust account. It's like having two separate bank accounts. What's important about this is that you need to make sure as money comes into the office, whether it's because a client is paying you money, whether it's because there's a settlement, where does the money go? You cannot what's called commingle funds. In other words, you cannot take money that doesn't belong to the law firm and put it into the law firm's bank account. So where this happens is, say there's a settlement, okay? A company agrees to pay your client $40,000. They are not going to send the money directly to the client because then you're never going to get paid. What they're going to do is they're going to send the money to you. So you literally get a transfer. You might get a call right now, hey, we're ready to wire this. What account do you want me to wire it to? If you tell them to wire it into the regular law firm's account, understand that's money that you're putting into your account, the law firm's account, that doesn't belong to the law firm. It belongs to the client, okay? So it's very important to understand that that money should be deposited in the IOLTA account. Okay, basically it's like a separate little pot that holds that money. What'll happen is the 40,000 comes in. Let's say the agreement was to pay 25% to the lawyer. The lawyer then takes the 25% of the 40, which is 10,000, takes it out, transfers it to their regular account, leaving the rest of the money in that account so then it can be sent on to the client. If you take that money in total and just dump it into your account, what's going to happen is it's going to draw interest on it. And that's where the violation occurs, because basically you're making money off of money that isn't yours, right? You're making money off money that doesn't belong to you. Now, granted, I know that interest rates aren't very high. It's not a lot of money, but it is a little bit. And so that money needs to be placed in the right place. That's where I'm going to finish up this first video. I'm going to be picking up with number 6 on the next video.